everybody. Assalamu alaikum, and welcome to our fourth theme session of the Africana Muslim and Genealogies of White Supremacy Sawyer Seminar for the Interdisciplinary Study of Blackness and Muslimness. The seminar, led by Professor Suad Abdul Kabir, Samir Ali, and Murad Idris, aims to address the ways the racialized figure of the Africana Muslim, i.e. Muslims from Africa and its diasporas, has been hypervisible in the theory and practice of racism since the days of Columbus, yet has been largely invisible in scholarship on critical race studies, white supremacy, and Middle East studies. Over the next year, the seminar will bring together leading scholars, thinkers, and activists to reconceptualize the study of the African and the Muslim and recenter the Africana Muslim beyond the cracks of traditional disciplines and narratives. Our goal is to trace the intersection of race and religion in the production and reproduction of white supremacy in both theory and praxis. The seminar is supported by the Mellon Foundation and housed at our home institution, the University of Michigan, whose origins are a land grant from the Anishinaabe, including Ottawa, Ojibwe, and Potawatomi and Wyandot tribes. Our university stands, like almost all property in the United States, on lands obtained in unconscionable ways from Indigenous peoples. Knowing where we are changes neither the past nor the present. However, through scholarship and pedagogy, we work to create a future in which the past is thoroughly understood and the present supports human flourishing and justice while enacting an ethic of care and compassion. Today, our session, Courts, aims to generate a wide-ranging reflection on these themes and questions by examining how the law has been a key instrument for exclusion and inclusion. How have laws targeting race been deployed in the context of religion and vice versa? Indeed, it was courtrooms that racialized religion in immigration cases, coding Islam and Muslim skin color as indices of difference, belonging, and humanity. This seminar will interrogate moments in which courts and legal systems produce and reflect these dynamics locally across the world and at the international scale. And today we are so honored to have Dr. Rabiat Akande lead us into this conversation. Dr. Akande is the Wilson H. Elkins Professor and Associate Professor of Law at the University of Maryland Francis King Carey School of Law. She chairs the International Legal History Project at the African Institute of International Law in Arusha, Tanzania. She is the author of Entangled Domains, Empire, Law, and Religion in Northern Nigeria, published by Cambridge University Press in 2003. And her other works, including an article titled "An Imperial History of Race and Religion in International Law," was published in the American Journal of International Law in 2024. So before handing it over to Professor Akande, I wanted to encourage everyone to please put questions in the Q&A function as they come to you, and we'll be sure to get to them in the Q&A afterwards. So without further ado.
I think you're muted.
All right, good, awesome. Thank you so much for that kind introduction and for the invitation really to join you in this really important conversation. I'm so honored to be here and to have this conversation with you all. So I will begin my remarks by drawing your attention to a debate that is currently unfolding at the United Nations over a proposal to extend the provisions of the International Convention on the Elimination of All Forms of Racial Discrimination, the ICRAD for short, that's a mouthful, to cases of religious discrimination. Now, that debate to extend the provisions of the International Convention that deals with racial discrimination to religion discrimination has been conducted in generic terms, but without a doubt, much of the discussions have centered Islamophobia. And in fact, a prominent vanguard of the proposal is the Organization of Islamic Cooperation, and several Muslim majority states back the proposal as well, but with significant support from other states from the Global South. The centrality of Islamophobia to these international legal debates is not surprising, as a recent report by the Office of the United Nations Special Rapporteur on Freedom of Religion and Belief notes, the contemporary world is experiencing, quote, epidemic levels of anti-Muslim hatred. And that conclusion is, of course, backed by overwhelming evidence with which we are all familiar with, including the reviling of Muslims in the media, violent attacks on Muslim communities, foreign invasions and killings, and the continuing global war on terror, the outlawing of the Muslim headscarf in several states in Europe and here in North America and Quebec in Canada particularly, the several iterations of the Muslim ban here in the United States, and of course, certainly without the list, the shocking ongoing erasure of Gaza. But as Professor Mustafa Bayomi reminds us, this historical and contemporary regime of Islamophobia is not just hatred, right? In the sense in which it's described in the UN report that I quoted. So that it's not just hatred in the sense of it being irrational. Rather, it is, to borrow the words of Professor Bayomi, a careful ideology. That ideology is one whereby Euro-America in particular defines itself in oppositional terms to the other, especially through the law. Law, in essence, constitutes the othering of Muslims, an othering that, as I will show in this talk, is simultaneously racial and religious. Now, if law has revealed itself as an instrument of oppression, the ongoing UN debate and other struggles that I will refer to later in my talk show that law is also being wielded as a tool to resist the status quo. The vanguards of the United Nations proposal that I described earlier, that is the proposal to extend international legal protections against racial discrimination to Islamophobia, argue that the experience of Islamophobia involves the interplay of racial and religious discrimination, but that experience does not, it's not redressed by international law. As I've shown in my own work, the lack of redress for those who experience Islamophobia is precisely due to the existence of a protection gap in the international legal framework, whereby those who experience Islamophobia are precluded from recourse under both the international legal framework on racial discrimination, but they are also denied protections under the international legal framework on religious liberty. And so they go to racial discrimination protections. They don't obtain recourse, but they are also denied recourse under the framework of religious liberty protections. To show what I mean, I use the example of the Muslim headscarf or veil. So obviously they're not the same thing, but for the purpose of my analysis, I will use them interchangeably. And I use that example because it has been in the spotlight. The Muslim headscarf or veil has been in the spotlight following bans and severe restrictions in the public sphere by several states in Europe and in North America. So as these legal restrictions manifest in contemporary Europe and parts of North America, it reveals a construction of the Muslim as a simultaneously racial and religious other. The discourses that legitimate those restrictions homogenize Muslims as an essentialized racial category, marking the Muslim other as foreign and fundamentally different. It is not only that Muslim women are demographically more likely to be phenotypically Black or brown, rather what is at issue here is a racialized construction of Muslimness by these legal restrictions. The discursive construction of the veil as innately Muslim, even as there are other religious traditions that are done the headscarf, and the framing of the covered Muslim woman's bid to live out that commitment to the veil as the natural and irrefutable antithesis of the universal civilizational ideals of liberty, security, and equality reveal the entanglement of racial and religious othering. Now, as I noted earlier, neither the international legal framework of religious liberty nor that concerning racial discrimination are responsive to this problem. So let us first consider the international law of religious liberty. Challenges against headscarf bans in the name of religious liberty protections have been overwhelmingly unsuccessful. That hostility to headscarf claims stands in tension, however, with courts and specifically the European Court of Human Rights permissive attitude towards Euro-Christian symbols. And I use the European Court of Human Rights because, again, the bans have been really widespread in Europe, and the European Court of Human Rights has has had to adjudicate many claims. And so much of the jurisprudence in this area is really that, from the European Court of Human Rights. So two cases illustrate this dichotomy by which the court is hostile to claims for religious liberty protections for the headscarf, while the court is permissive towards Euro-Christian symbols. The first case is the court 2001 decision in Dahlab versus Switzerland, in which the court upheld the regulation that precluded a Swiss Muslim convert from wearing a headscarf at a public elementary school where she was a teacher, for effectively denying her religious liberty claim. The court reasoned that to allow the adornment of the headscarf in schools would violate the principle of the state's neutrality towards religion. However, in the 2011 case of Lozzi versus Italy, the same court upheld the presence of crucifixes in Italian schools, ruling that those symbols are an evidence of Europe's Christian culture and history, rather than religion per se. Now, although these decisions appear to be irreconcilable, and in fact, scholars have been confounded, but then they actually do illuminate the mutual co-constitution of racial and religious othering in the construction of the headscarf. In fact, the court's conception of what is religion and what is not, of what forms of religions are worthy of protection and of what forms are not, is intimately linked with a civilizational distinction that is at the same time racial as it is religious. The court's construction of the headscarf as religious legitimates the homogenization of Muslims as an undifferentiated whole, and when fused with a presumption of the moral, cultural, and religious foreignness of the veil, that homogenization then places Muslims as an outsider to the Western social order, at once a religious and a racial order. Consider, for instance, the court's conclusion in Dahlab that the headscarf code appears to be imposed on women by a precept which is laid down in the Quran and which is hard to square with the principle of gender equality. That discourse racializes Muslims by projecting gender oppression onto Islam and naturalizing that gender oppression out of it. By doing so, the unveiling discourse defines Christian European civilization as the very opposite of the veil. The consequence is that claimants like Ms. Dahlab would fail in appealing to religious liberty protections. However, Ms. Dahlab would also fail were she to seek protection within the racial discrimination and protection framework, even as the legal restrictions she's challenging undoubtedly racializes the headscarf. Right? And so again, she would be unsuccessful in seeking religious liberty protections, as I've already shown, but she would also be unsuccessful were she to seek protections within the framework that protects against racial discrimination. And that is because, as it is currently constituted in law and expounded upon in jurisprudence, the international legal framework on racial equality hinges on a somatic understanding of racial discrimination, one that continues to construe racial discrimination primarily in terms of biology, or if you will, skin color. That construction of racial discrimination would not accommodate Ms. Dahlab, the white Swiss Muslim convert, but it would also not accommodate phenotypically Black or brown women who bring claims for racial discrimination for the headscarf. And so what I'm trying to explain, in essence, is that these Muslim women claimants, regardless of their skin color, would fall through a protection gap. Notice, however, that it is not only that a protection gap exists, but that protection gap is constituted by the law itself, right? So it's not a blind spot, it's not an accident. Law, in essence, simultaneously constitutes the othering of headscarved Muslim women, and yet renders that othering invisible and irredressible. Now, the current United Nations proposal that I described at the beginning of my talk, that which seeks to close the protection gap that I just described, is not the first attempt to interlink international legal protections for racial and religious othering. This current proposal, in fact, replaced a 1962 effort to craft an international legal convention addressing the question of racial and religious discrimination as intertwined legal problems. The African states that sponsored that mid-20th century proposal and that had only recently emerged from the clutches of formal colonialism were deeply concerned with the global condition of racial and religious othering that undergirded the European imperial venture in Africa. And so these African states were actually the one that, that were putting forward that 1962 proposal that is, somewhat similar to the current proposal in that it sought to address the problems of racial and religious discrimination as interlinked problems. Racial and religious othering in the colonial encounter were not merely intersectional. In fact, European colonization of Africa was premised on a mode of othering in which race and religion were mutually co-constitutive. The racial other was simultaneously the religious other. That mutual co-constitution, of racial and religious othering was evident in the imperial discourse that permeated the series of conferences convened in Berlin in the 1880s to negotiate the parceling out of Africa among European colonial powers. The Berlin processes were founded on the premise of the superiority of the idea of Western Christian civilization in court, and delegates to the talks were firmly convinced of the close connection between Western culture and Christianity, and for them, the absolute cultural superiority of the Christian West was not a matter of debate, to cite some of the scholarly writing on the conference. To understand who the African was in relation to the European was to appreciate how the African's race was co-constitutive of her religion in the imperial discourse. Many delegates embraced the theological understanding that Blacks had inherited Noah's curse. So, all of this is, pretty well known, biblical analogies that were, invoked to justify the racial subjugation of Africans. But I seek through these analogies to show how that racial othering was co-constitutive with the religious othering. And so theological, there was a theological understanding that Blacks had inherited Noah's curse from their late ancestor, leading to a divine chastisement for Africa. The colonial venture was therefore a response to the call to light those living in darkness. And so this was the discourse at Berlin. The vehicle for that project to civilize was the mission that sought to Christianize Africans on European terms. Yet, the mutual co-constitution of race and religion in that project made that goal of civilization unattainable. As Dr. Edward Blyden famously noted, true conversion to Euro-Christianity was impossible since the African, by the very fact of his Africanness, could not aspire to be Euro-Christian. And so there were therefore already tensions within that Christian civilizational project, and those tensions found expression in law. Consider, for instance, the Berlin General Act of 1884, which was the legal instrument that was produced by the Berlin negotiations. On the one hand, the Berlin Act conferred religious freedom on all, but by that same legal provision through which it conferred religious freedom, that is Article 6, European powers committed to, among other things, instruct the natives in court and bring home to them the blessings of civilization. And so this civilizational venture already undermined the purported grant of religious liberty, since Article 6 evoked a European civilizational superiority, an idea that translated into a race-religion hierarchy. And so that hierarchy, that race-religion hierarchy already defeated the religious liberty that was purportedly granted by the Berlin Act. By legal definition, the native described in the Berlin Act, that is the native that was the object of the civilizational project, was Black, was African, and was non-Christian, always necessarily an other to the European. For all of Europe's homogenizing gaze, however, the native, again in court, did not operate as an undifferentiated category in practice. There were degrees of othering, culminating in intra-native distinctions. So notably, Islam was regarded as the quintessential other, leading Muslim African societies to be of primacy to the missionizing and more broadly to the imperial project. As historian Thomas Prash put it, for the late Victorian missionary enterprise, Islam represented the quintessential other, the faith that was most resistant and most competitive. And for Victorians, Africa was the obvious arena of contention, the blankest continent on the imperial map. Now, if that presumption of Africa as a blank state hinged on a civilizational ordering that was simultaneously racial and religious, the Muslim African was understood as the paradigmatic author of Christian civilizational attainment. This intranative differentiation that I highlight illuminates degrees of precarity while simultaneously underscoring the centrality of race-religion authoring to Europe's colonial subjugation of Africa. In fact, as the first governor of northern Nigeria, Frederick Lugard, famously noted, quote, "Islam is incapable of the highest development, but its limitations suit the limitations of the people," that is, of Africans. Europe's subjugation of these others took the form of unleashing violence, some of the more notable examples being those of the early 20th century British colonial massacres of Burma, Sadira, and Dumbulawa in what we now know as the present-day northern Nigeria. As one official colonial source concluded following the massacre of Satiru, no wall or tree was left standing. These Black African Muslims were Europe's paradigmatic racial and religious others, yet the heightened vulnerability of Black African Muslims does not obscure the othering of African Muslims who are not Black and of Black Africans who are not Muslim. Rather, centering the Black African Muslim in the telling of this history helps to simultaneously illuminate the mutual co-constitution of racial and religious othering that is evident in Europe's construction of the African, while also mapping the distribution of oppression and vulnerability. Consider how the race-religion construct illuminates France's well-known crusade against the Muslim veil in North Africa and in Algeria in particular. That French agenda was at once racial and religious. Indeed, the image of the veiled Muslim woman was a racialized one, functioning, according to Alia Saji, as, quote, "the negative mirror in which Western constructions of identity and gender can be positively reflected." The colonial gaze projected gender oppression onto Islam and naturalized that oppression onto the bodies of Muslim women, effectively racializing the veil and Muslims. But that project was not merely racial. Religious othering was bound with that racializing project, even as the French colonizer banded justifications of laicity, that is France's unique and historically contingent brand of secularism. That project was not neutral of religion. In fact, the so-called secular public space that required unveiling contradicted only some religions and not others, with the consequence that it functioned to preclude only the racial other's religious expression. By doing so, the race-religion discourse thrived in the French project as it did in British territories. As formal colonial exploitation unfolded across Africa from the late 19th century onwards, the African and Muslim, earlier transported across the Atlantic as chattel, continued to experience violent exploitation and dispossession, even following the 13th Amendment's abolition of chattel slavery in 1865 here in the United States. Of course, according to some accounts, up to 40% of enslaved persons transported across to the Americas were from Muslim parts of Africa. Even as law brought slavery to an end formally, law too had legitimated enslavement and continued to legitimate the many legacies of slavery, including modern incarceration. But just as African states were in the United Nations 1960s debate wielding law to contest the race-religion authoring that empire had institutionalized in Africa, law too was being wielded by African and Muslims here in the US, including to challenge the modern carceral state. In fact, as the 1960s United Nations debate over a convention addressing racial and religious discrimination was ongoing, some of the earliest coordinated legal struggles that highlighted the connections between racial and religious subordination unfolded in prisons here in the US. Presented in Garrett Felber's groundbreaking work, that story of the prison's brutal treatment of these Muslims in the form of surveillance, among other brutal forms, much more brutal forms of punishment, was precisely a product of what I read as a mutual co-constitution of race and religion and the state's othering of these Muslims. The carceral state sought to neutralize this legal resistance by disentangling religious and racial discrimination. Over and over again, prison administrators sought to argue that these African and Muslims, and specifically Nation of Islam Muslims, were Black rather than Muslims, and that the religious protections that they sought on the basis of their Muslimness, such as not eating pork, having access to religious literature, accessing cells that face the East, were in fact illegitimate claims precisely because these Muslims were not, these imprisoned persons were not Muslims and therefore not entitled to religious liberty. However, as the prison administration was seeking to elide the Muslimness of these imprisoned persons, civil rights movements' construction of the ideal defendant and media and law enforcement's demonization of the Nation of Islam meant that these imprisoned persons had come to also be regarded as racially insular. And so the consequence was that even as they were being deprived of religious liberty protections, they were also marginalized in the modest gains of the struggles for racial equality. So I will come back to these legal struggles in the prison later in my talk. For now, I emphasize that just as the interplay between racial and religious othering marginalized African and Muslims in prisons in the US, while also depriving them of legal protections, the interplay of religion and race in the native identity simultaneously subordinated the African and Muslim in colonial Africa as well. Yet, law was not only a tool of oppression on both sides. In colonial Africa, as in settler colonial US, law was simultaneously a tool of oppression while also being an instrument that the oppressed looked to in hopes of resistance. It was too often, however, that resistance met a tragic end. The 1960s United Nations proposal to formulate an international legal provision in response to race, religion, othering was neutralized precisely due to the imperial relations of power that instantiated and sustained Europe's othering of its race, religious other. So I refer in particular to a disagreement between the United States and the former Soviet Union over whether it was racial discrimination that was more deserving of global attention in the 60s, or whether in fact the true evil of the time was religious discrimination. While the United States argued that the true international legal problem of that time, that is of the 60s, was religious discrimination, and cited that religious discrimination particularly manifested in state and societal anti-Semitism in the former Soviet Union. The former Soviet Union argued that racial discrimination as it manifested in the United States to the attention of the whole world was in fact the true evil of the time, right? So those were the years when global attention was, affixed to, white resistance, to the Supreme Court's ruling on desegregation in the US. But I want to underscore that global attention centered, right? So both global attention, right, more broadly, but also the UN debates centered and cited the mainstream civil rights movement, right? That experience and that, response, right? That organizing. And that elided, of course, the salient and ongoing African and Muslim struggle against race, religion, othering that was ongoing in United States prisons at that time specifically. In the end, although the United States and the former Soviet Union disagreed over whether racial discrimination or religious discrimination was the true evil, they were in agreement that the racial and religious dimensions of that proposal be disentangled, right? So they disagreed about whether the world ought to focus on racial or religious discrimination, but they were both in agreement that those were separate things and should be considered separately and dealt with separately. That USSR disagreement defeated the proposal to interlink protections for racial and religious discrimination in the same international legal instrument as those African states sought in the 60s. Ultimately, the United Nations General Assembly resolved to adopt separate international legal instruments, one that addressed racial discrimination, and the other that would be concerned religious discrimination. The instrument that addressed racial discrimination, the ICERD, the convention I referred to at the beginning of my talk, was adopted in 1965, while the Convention on Religious Discrimination never materialized. And so what was left for religious liberty was an international legal framework that hinged largely on Article 18 of the Universal Declaration of Human Rights, which had come into being 2 decades earlier in 1948. But as critical histories of Article 18 of the Universal Declaration of Human Rights have shown, that legal provision was a product of a careful effort by global ecumenical missionaries who were seeking protections for the Universal Christian Missionary Project. The result of that effort, that is Article 18, was a legal provision that was Christian preferentialist in its conception of what forms of religion were worthy of protection. So I stress here that the legacy of this disentanglement of racial and religious liberty protections as a result of the 1960 story is to render the mutual constitution of racial and religious othering invisible in international law. And that continues to mask the othering of Muslims and the heightened precarity of the African and Muslim. That masking remains alive in legal, juristic, and institutional discourses. On the one hand, racial and religious othering are rendered mutually constitutive precisely through legal and institutional constructions that are evident in Europe's discursive colonization of Africa, as in the carceral state discipline of African and Muslim prisoners. On the other hand, however, that mutual constitution is elided precisely through law and the state's insistence on governing the categories of race and religion, a governance project that simultaneously defines, confines, and hierarchizes. To underscore the central point again, law simultaneously constitutes race-religion othering while also rendering it invisible. So I already made this point earlier at the beginning of my talk when I discussed the Dahlab case, the case involving the white Swiss Muslim convert, right? That in which the court racialized the headscarf to deny the headscarf religious liberty protections, even as Ms. Dahlab was precluded from obtaining recourse under racial equality protections, right? Although, as I've shown, both the legal restrictions on the headscarf and the court's jurisprudence itself racialized the headscarf, right? And of course, as I noted, Ms. Dahlab would not be able to get recourse because racial discrimination continues to be construed in phenotypical terms, precisely as a result of the history that I've narrated. The history, as I've noted, of the disentanglement of racial and religious othering in international law. Law's simultaneous construction and elision of race-religion othering is also apparent in the 1960s struggles of Nation of Islam Muslims. The coding of these Muslims as Black did much work to discredit their claim to being Muslims, but the effect of not only alienating them from the Muslim world, but also of frustrating their claims to religious liberty protections. The courts were a site for that battle. Consider, for instance, the 1964 Socher versus McGuinness case and the 1966 Samarian versus McGuinness case. Cases in which allegations of the violation of religious liberty by Nation of Islam prisoners came to turn on the genuineness of their claim to Muslimness, right? Given that the prison authority contested their claim to being Muslim. In ruling over orthodoxy, the district court had to square two opposing positions, that of Malcolm X on behalf of the prisoners, who summarily claimed, that is, Malcolm X summarily claimed what he would later note in his book, that, quote, "We are Black people here in America, our religion is Islam," right? So that was one position. But the other testimony before the district court in Samarian was that of Joseph Schacht, who was an eminent professor of Islamic studies at Columbia, and who sought to discredit that claim to Muslimness. Now, although the court eventually held that the Nation of Islam was a religion with rights in prisons, the court finding that Nation of Islam was not an orthodox Muslim group is striking. To be sure, debates over orthodoxy are foundational to internal Islamic juristic discourses, right? So that discussion would certainly have a place within Islamic juristic discourses. However, law's assumption of the authority to determine who counts as a Muslim is a tremendous exercise of regulatory power, one that I've argued grants the states the prerogative to define, confine, and in the end, hierarchize religion in spite of the state's claim to neutrality and secularity. By assuming the power to determine orthodoxy, the court disentangled Muslimness from Blackness and elided Muslimness, even as the experience of these imprisoned persons could not be understood through the prism of race alone. However, it is not only religion that is elided, race too is elided in law's construction of Muslims. That conceptual elision of the place of race and of racism in the workings of Islamophobia is evident in Trump versus Hawaii, the United States Supreme Court decision on Presidential Executive Order 13679, colloquially known as the Muslim ban. In response to arguments noting the similarity of the Muslim ban with the court's infamous 1944 Korematsu decision, that in which the court had upheld the internment of Japanese Americans during World War II, the court, and specifically Chief Justice Roberts for the majority, declared that Korematsu has nothing to do with this case, that is Hawaii. Chief Justice Roberts noted that, quote, the forcible relocation of United States citizens to concentration camps solely and explicitly on the basis of race is objectively unlawful. The court therefore insisted that while Korematsu involved a racial classification, Hawaii involved a question of religious classification. In fact, however, it was precisely that by making that distinction between racial and religious othering that the court was able to remember Korematsu and yet forget its lessons. The Hawaii decision reveals how law not only constitutes the race-religion othering of Muslims, but also renders it invisible. That race-religion othering is not merely intersectional, rather it is in fact mutually co-constitutive in that the Muslim is at once a racial and a religious other, even if they are white, as is revealed by the headscarf bans. This point about the mutual co-constitution of race, religion, othering of the Muslim does not undo the realities of intra-group vulnerability. Blackness is salient, placing African and Muslims in a position of heightened vulnerability historically as today. Therefore, although it is crucial to begin with a history-informed understanding of the mutual co-constitution of race and religion in empire's othering of its paradigmatic other, the Muslim, that analysis cannot end there. It must be followed closely by mapping the distribution of oppression. The genealogy of race, religion, othering that I've shared over the past couple of minutes has attempted to be attentive to that distribution by showing how law was deployed both as an oppressive tool of race, religion, hierarchy, and how oppressed African and Muslims look to the law for possibilities of resistance. This story shows how centering the margins can unveil the enduring historical structuration of the race-religion distinction in spite of law's insistence on masking it. Thank you so much. I look forward to our discussion.
Oh my gosh, what a round of applause. That was such a lucid framing of such complex systems and time period. So thank you so much. I'm obviously very excited about this. Before I make a question, I just wanted to invite anyone else if they have a question that they would like to ask. Yes, Professor Swad.
Okay, thank you. Thank you so much. Yeah, this was fantastic. I mean, so first I have a comment, right? I just think in terms of the connections you're making from like the colonial period through to the kind of, so the rise of like the international courts in the UN, like, and then also taking us domestically back here to the United States in terms of the courts, and even until like the 21st century. So I mean, it's like, so the thread that you sort of laid out for us, I thought was really important. And also, one more comment, just in terms of your point about the civil rights movement and the time, which is 1962. I think it was a convention you said, right?
Mhm.
How like it kind of got neutralized, right? Because racial discrimination was like considered the most important thing. But to me, that also spoke to the ways in which kind of Blackness and Christianity become elided in the US
Mhm.
context, thereby utilizing more radical Black freedom movements, right? So the ways in which like Black Muslims in a US context represent a more radical, fundamentally can represent and have represented a more radical sort of Black freedom movement, like sort of that kind of work, and are people who've been like Malcolm, for example, like going to the UN, or saying like this, the you know, the case of Black folks in the United States is not just about civil rights, but it's a human rights thing. So I really love that as well when you brought that up. But my question was about going back to the continent and this colonial period, and something you said, you said like the Muslim African as a paradigmatic other, right, of this kind of Christian civilizational colonial project. And I was wondering about that in relationship, and you kind of talked about this a little bit, you talked about Algeria, but I'm somewhat familiar with the ways in which, you know, this idea of Islam noir and like that African Islam is not really Islam in a way. So I was wondering if you could speak more about how kind of like Blackness, like, you know, like were they different, right? Like in Nigeria versus in Algeria, right? Or in Levant, you know what I mean? In terms of how they understood what the Muslim other, you know, who that Muslim was, and you know, that type of stuff. Yeah.
Yeah, that's a really great point. Really, really great point. I mean, your previous your comment, your initial comment with how Blackness and Christianity became sort of collapsed. I mean, not only here in the US, but also in how the ongoing struggles in the US were being understood, and debated on in the UN. So as I noted, even as the United States and the USSR disagreed, right? At the UN, the examples that were being brought forth were those of the mainstream civil rights movement. And so there was really this elation. It was like, and so the Muslims, they don't get sin on the race, but they also don't get sin on their religion, right? Which is what is really, really striking, right? So, when I think about, that gap, what I describe as that protection gap in which you go to race, you're not sane. You go to religion as well, you're not sane. So what is going on here, right? How is this gap constituted by the history, right? And so this point you make about Blackness and Christianity, right, in the U.S. context, and what it actually meant for those international legal debates, for the framing of the problems, and what was being sought to be redressed, that is incredibly, incredibly powerful. And so I really take note of that. Second point as well, how is Africanness, how is it not seen, right? As being Muslim, right? How is that elided, right, in Muslimness, right? So how do we, lose, the African and the Muslim? And that's really interesting to think about, both from the perspective of the colonizer and the perspective of the colonized, right? As, not as, homogeneous categories. And so for the colonizer, there's been a lot of just so much energy that has gone into, distinguishing British imperial thought from French imperial thought. But really, I think on this question of race, religion, authoring, right? Although, it might seem on the surface that what the French is doing is that was just racial, right? They didn't care about religion, right? It's, this is, post the French Revolution, and it's about laïcité. But it was very much both. It was very much about race and religion. The construction of the Algerian was simultaneously racial as it was religious. And I'm actually working on a piece now in which I'm actually sort of really, really diving deep into the colonial discourse. And I'm seeing ways in which it was very similar to what the British were doing in the territories. And so let's use the example of the Unveiling Project. So there was an unveiling project in French Algeria. There was no unveiling project in Northern Nigeria. And I use Northern Nigeria because Northern Nigeria is considered by historians as really being this, this extreme place. I mean, it was the only place in the British Empire, apart from parts of what we now know as Yemen, where the British colonial state applied Islamic law as criminal law. So like it was like this is really different. And so there was no unveiling project in British northern Nigeria, but there was a French unveiling project in Algeria. So how are they the same? And yet the same precisely because for the British Empire, for the British colonial state, the African Muslim was a paradigmatic one. And so that othering already negated the idea of an unveiling. But in French Algeria, yes, there was an unveiling project, but that unveiling could not negate the race region. And so conversion to, as I noted, citing Dr. Blyden, if you could become Christian, but you could not become European Christian. And so true conversion was in the end not possible, right? And so the colonial project was premised. And so this is, it's what we, describe in, in legal issues of colonialism, as, the sort of the dynamic of difference or the paradox of difference sometimes. The colonial enterprise was premised, right, on the idea of difference, right? So we are colonizing because we want to, because we want to bridge this gap of difference, right? We want to, we want to eradicate this difference, we want to usher them into the world of civilization. But of course, the survival of that project was premised on the continuation of that, on the survival of that difference. So to eliminate the difference was precisely to defeat the colonial project. And so that, and so the goal could not be attained, right? So, because again, to attain it would be to defeat the project. And so that's from the colonizer's perspective. And I know we don't have much time. From the colonized perspective, it's very interesting how, for instance, in sub-Saharan Africa, and I've, my book and much of my primary research, centered on Northern Nigeria, how, there are debates over, what it means to be the ideal Muslim, what to look for. And so, for instance, in the late 1950s, when there were negotiations over, independence, the colonial state said, well, if you will gain formal independence, at least you have to learn how to be modern. And for you to learn how to be modern, you have to figure out when the world Muslims have learned how to be modern. So you have to, look around and search out what states have done so successfully. And so there were debates about, well, do we go to Egypt? And Egypt they're much more Muslim than we are because, after all, they speak the Arabic language. And so there were those internal debates, right? Even, right, among the colonizers. And so that's from sort of the perspective of, the Black, Africans. And so in the Northern Nigerian story, they travel to, they don't go to Egypt because the colonial state was very worried about what it understood as some radical elements in Egypt. But they go to Pakistan, they go to Libya, they go to Sudan, and they try to figure out, well, how have you learned? So the point is that these discussions about, hierarchies of Muslimness were very much present. Well, they were very much present, right? Even among the colonized population. So it was not, merely one. So suddenly there was colonial discourse that, projected and understood, Muslims were Arab as being more Muslim, but certainly the colonized population also, began to speak in those terms for sure.
Thank you so much for that. You briefly touched on this question in your response now, but I just want to ask it just to give the opportunity for you to address it fully. But so one of the attendees said that they're really curious about the effect of the othering of African Muslims under British colonialism when they were also privileged vis-a-vis pagan Africans, particularly in northern Nigeria. Could you go more into that?
Yeah, so that's a really, really good point, and one that I think about a great deal in my book, in which I really grapple with the question, well, how does a colonial state as that in northern Nigeria, where the state is in fact governing through what remained of the pre-colonial polity, the pre-colonial caliphate, also claiming, right, that it's secular and distinct from religion. And I show, and I show in the book that in fact, the colonial state's governance through, these Islamic, what remained, I would not call them Islamic, what remained of the pre-colonial caliphate institution was not only governing through them, right? So there was indirect rule, indirect governance, through indigenous institutions, which and the ones that were used in northern Nigeria were in fact, Muslim institutions, was not only governance through, was also always governance of, right? And that's really important to note. And this is how one is able to actually see how colonial governance for sure hierarchized faiths in a way in which the state seemed to formally and ceremonially adopt Islamic institutions as the vehicle through which it ruled, and in which the state was allied with a certain Muslim elite. But this colonial governance was also very much premised on instituting to adopt Professor Mamdani's and Professor Reynolds' classification, a good Muslim, bad Muslim distinction. Right? It was very much, and so that hierarchy was not merely one of sort of a Muslim pagan hierarchy. It was also one of a good Muslim, bad Muslim hierarchy, right? And so some of the examples that I've shared today, so I shared examples of the colonial massacres, in part of Nigeria, in which the colonial state describes, in which a report following the attack, describes the situation and says no warlord, she was not standing, and so. A lot of violence, was inflicted. And in fact, that, and so it is crucial that when we think about colonial governance, when we think about the formal adoption of these institutions, when we think about these formal alliances, that we actually go beyond that to understand what it actually meant, right? That we when we understand that it was governance of, we see the ways in which forms of subordination were not only one, that pitted Muslims against non-Muslims, that there were intra-Muslim forms of subordination, and one in which violence was very much used as a tool to subordinate.
Thank you so much. I have a question. So just in a very lucid way and across time and place, you showed us the way that race and religion are co-constituted in civilizational discourses around the other. And that brought me back to a discussion that we had in our very first panel on prisons. And we talked about this term anti-Muslim racism over the term Islamophobia and the benefits and the pitfalls of that. And it just made me think, is that term, because state logics and courts parse race and religion, is that term anti-Muslim racism, in your opinion, helpful about thinking about religion and race and within legalese, if only?
I mean, I spend a lot of time thinking about it. Most of the time I tell myself to not bother. I mean, I have had my own challenges with what might be the problem with using the term Islamophobia. But I worry that when we use anti-Muslim racism, that we might elide the religious dimensions of that racism, right? And and I mean, we might say, well, once we include anti-Muslim, then it's already presumed that there's a religious dimension that is going on. But I worry that there is a that so claims of racial protection hit a wall, right? All the time, internationally, locally, globally, everywhere. But when it's a claim that has a religious dimension, it's even worse, right? And so what do I mean by this? So I use the example of international jurisprudence that concerning hate speech. So courts have been more receptive to claims that seem to have a racial dimension of its speech. So courts and international adjudicatory bodies have been more receptive to claims that seem to have a racial dimension, as opposed to those that are framed as religious alone, even as you cannot actually understand the religious dimension without understanding the race dimension. So this is what I'm trying to this is what I was trying to describe when I was describing the experience of the white Swiss Muslim convert, that it's not that she would fail under the religious liberty framework because of the issue that I've described, but she would also fail under the racial equality protection. And it's not only the white Muslim convert that would fail. The Black or brown Muslim woman would also very likely fail, right? Although we don't have a test case yet, would also very likely fail if they were to bring that claim for the headscarf as such. So it's 2:59. The Committee on Elimination of all forms of racial discrimination, which is the UN body that is that has the mandate of thinking about and implementing and educating claims regarding the ICERT, the International Convention on the Elimination of all forms of racial discrimination, has held that yes, Islamophobia could constitute could constitute a form of racism. But when the committee actually was faced with a claim that alleged, that touched on Islamophobia, in the continuing global war on terror, the committee held that yes, although Islamophobia could consider a form of racism, this case touches on religion alone. You see what I'm, so it's, I worry about what we might mask by using anti-Muslim racism, but I also worry about using Islamophobia. I mean, most of the time I just tell myself, say what you're talking about, use the terms you're gonna use, but also recognize that, it might be a distracting discussion. In fact, I've had, I've had, a comment, on the review of my works, really attacking the term Islamophobia and delegitimizing the term, right? Even as I was speaking in that article of other forms of race, religion, othering, and none of those other forms of race, religion, othering were attacked, right? So every other term for other forms of race, religion were good, but for Islamophobia, and so when I think that, well, there is that this might be distracting, right? Because in fact, those who seek to delegitimate, the project seek to delegitimize the term itself. And so I will not go down into that rabbit hole. I will just do my work, but we do have to be aware of the forms of elision, right, that these terms might bring into being, and that law itself seeks to do this work of masking, and that we always have to be aware of that and have to be, much of the work I would say at this stage is actually doing the unmasking, right? Unmasking of the ways in which law would constitute this race and religion othering while also masking it, right? And making it invisible. So that is the work at this stage, I would say.
Thank you so much, Professor Akande, for this. I mean, you just really, just all of the lessons in each of your responses and your keynote lecture that, for myself personally, when we're talking about the law and legalese, I often think like, oh, it's so complicated. How do I enter into it? And I feel like I'm going to keep returning to this lecture as spaces where I can enter into this conversation. So I just wanted to thank you so much for joining us today, and a virtual round of applause for you and for your incredible scholarship and the way that you just really just taught forward what you do clearly so well. So I wanted to just let everybody know in the audience as well that we have a next series of panels that's going to be happening in April. And that's going to be thinking about the Africana Muslim specifically from the lens of theory and pre-modern and modern conceptions of who the Africana Muslim is. And you can find out more information about that by going to bit.ly/Africana Muslim. To also sign up for our mailing list and get information on that. So thank you everyone for joining us this afternoon.